know that the hour is down and under that. Just a twisted pink paper clip clinging to a bit of jacket zip. Know that you won't get an acquit. Yeah, know that the hour is drawing near. The case is resting, Sarah Boone should fear. She might soon be shedding actual tears. Down and under that, just a twisted pink paper clip clinging to a bit of jagged zip, doing nothing more than slip and stick. As Sarah tries to hide her abusive lies, but know that no, it's you, Sarah, we all despise. Leaving you with your lifetime of demise from your sad attempts being the victimized. Know that, yeah, know that. All that you're really gonna see is Prosecutor Jay giving proof to the jury of your murderous pine for commissary. 6-panel conviction arrived at convincingly. Oh, Sarah, can't you tell that your time has come to ring the bell? And let your fans dole you some small slice of hell. The bailiffs will be waiting, cuffs in hand, since you fumbled and flopped all over the stand. So go on, say bye to your circus jaunt. Go on ahead, keep pretending to flit and flaunt. You'll soon be in your brand new prison haunt. Damn it, Margaret. Oh, Sarah, know that now is your time to return to your jailhouse lies. Your face and sob story past its prime. Yeah, know that. All that you're really gonna see is Prosecutor Jay convincing the jury of your murderous and dangerous lies. A sad attempt at trying to be the victimized. No, not happening on board DAJ Enterprise. Clip, clinging to a bit of jagged zip, which does nothing more than slip and stick. As Sarah tries to hide her abusive lies, but know that no, it's you, Sarah, we all despise. Your angry and controlling attitude won't spare you any grace or fortitude. From the truth, the jury all can see that the time is here, your taunts aside, to return to your crummy jail slide. Your face and sob story are past the prime, so go on, say bye to your circus jaunt. Go on ahead and keep pretending to flit and flaunt, because you'll soon be in your brand new prison haunt. Damn it, Margaret. Just a twisted pink paper clip clinging to a bit of jagged zip. Yeah, know that you won't get an acquit from all your murderous and dangerous lies. Pathetic, you claim to be the real victimized. No, not happening on board DAJ Enterprise. Damn it, Margaret.
Damn it, Margaret. How are we, everyone? How are we? The day is here. The day we've all been waiting for. Well, once the trial was ended, the day we've all been waiting for since the trial was ended. So there's been some stuff on that's hit the docket today, and I kind of wanted to go over it with you guys. So basically, the defendant has filed a motion for a new trial based upon a couple of complaints that they've had. And in regards to that, the state has posted their response, which is basically you have not a leg to stand on with that by Florida law. And they've also posted a bunch of items such as like the whole transcript of when Dr. Tanya Warner was up on the stand. Now Tanya Warner, she was the state's expert witness who did the psychological eval on Sarah. And then this morning, the defense came back and they posted the psychological eval from their person, which was, what's her name? Hang on, let me open this back up. Julie Harper. which it's the thing by Julie Harper. We can't get into it. It's one of those that it's locked. There's also a pre-sentencing investigation item on the docket that's also locked right now. So all we can really do is look at what they have here, which is this um, the state's response. And so I thought we could kind of look at that together if you guys would like to do that while we wait, because we've got, hey, Mark, thank you for being a member for 14 months. It's like being married. And it just keeps getting better and better with time, doesn't it? um, I'm gonna pull this up real quick because we still have what we got a few minutes. We'll look at this, and then if I need to pull this off and change back over to the other screen, I can. Go out so you guys can see it real well. So they're basically saying, look, you filed for, this is the state's response and to the defendant's filing for a new trial. And they're basically saying under Florida rule of the criminal procedure 3.620, no, you don't have a chance. And then they said that the defendant is overstating the holdings of the case she cited. And again, they've referenced Florida rule of criminal procedure 3.600. Because see, in part of Owen's request for or not a request, demand for a new trial, it was that whole, you wouldn't let us have an extension after we had new counsel, which you should have done. And what was the other one that he said? That you actually tried not to allow her to have counsel. That's what it was. You were going to let her defend herself. Like, all this stuff is just crap. And so the state says a defendant's right to counsel of his or her choice is not absolute, and a court's consideration of any continuance should balance the defendant's right with consideration of the impact on the administration of justice. They cited this. It says any denial of continuance to obtain new counsel must be based upon an adequate inquiry into the circumstances with findings to assure the defendant's constitutional rights were not being deprived. The court's 16-page order dated June the 28th of 2024 adequately addresses the circumstances of the defendant's forfeiture of her right to counsel and the setting of a trial certain date of October the 7th of 2024. 56 months after she was arrested for this crime. The court did not abuse its discretion by denying a continuance in this matter. The case was over 4.5 years old because of the defendant's issues with multiple prior attorneys, issues created by her behavior. The underlying work on the defense of self-defense and battered spouse syndrome evidence to be used in support of a claim of self-defense has been done by prior counsels. Much of the records disclosed to the state in October of 2024 had been acquired years ago but by prior counsels via subpoena and provided to private investigator Billy Lane. The Florida Supreme Court requires only 30 days notice prior to trial for a defendant to rely upon battered spouse syndrome evidence. In this circumstance, with the expert already working on the defendant's case for years and relying upon the records the defendant had in her possession for years, it was the state that had only 30 days to handle this evidence, after prior counsel had indicated it would not be filing a notice of intent to rely on battered spouse syndrome. And you guys remember that was true. First he came back and said he was going to do it, and then he said he wasn't going to do it, and then he kept putting up all these little barriers, or I would say barriers. He kept putting up all these little things, telling the judge, we're going to do this, we're going to do that. And the state would come back and go, you can't just wait to the last minute to drop all these bombs on us. Yeah, you're here late, but we've been here for a long time. Doesn't mean you get to come in with this last minute stuff. It's not happening. So the other thing that they said was that the state's witness, Tanya Werner, did not give them prior notice of what she was going to testify to in regards to Sarah's psych evaluation, which is crap. But we're going to get to that in just a minute. Let's see. It says, while it did take time to review the entirety of the defendant's phone extraction, the state was able to do so in the same time frame and narrow it down to 167 pages of PDF timeline and 213 photos and videos. The phone extraction had been provided years ago to the defendant's prior counsel. It was again provided to the defendant while she was pro se. The 911 calls and body-worn camera footage from the prior incidents took approximately a half a day to review, and that was accomplished after it was learned on October 1st of 2024 during her deposition that Dr. Julie Harper relied upon them. These were provided to the defense on October the 4th of 2024. There was an entire week of no action taken by the court between October the 7th of 2024 and October the 14th of 2024 because of Hurricane Milton. That and the excuse me, y'all. Sorry, Bruiser's having a fit. That and the prior 5 weeks was more than sufficient for a team of 4 attorneys and a trial consultant to review the material if the undersigned could. The court should not grant a new trial based upon this ground. Okay. Ground 3, homicide survivor outburst during the presentation of the evidence. Now, this is the part where James Owens stood up and threw a hissy fit like a 2-year-old in front of the court and said, "Oh my God, you can't be making noises and crying when we're showing these videos." Because remember, George Torres's mother got upset when they were playing the video of him in the suitcase because she had never seen it before. So she did make some noise and she was crying out loud. And of course, you know, he said he turned to her and tells her to get out of the courtroom. And then he throws this big hissy fit and says, you know, because she did that, now the jury's tainted. You can't take that back, he said. You can't undo that, I think is what he said. So it says during the publishing of the exhibit, which contained that video, apparently a single family member of the homicide survivors had an emotional reaction and left the courtroom. The undersigned's back was turned and did not witness this. The family member did not return for the duration of the evidence presentation. It cannot be said that this nonverbal, single emotional outburst was so prejudicial so as to vitiate the entire trial. That's true. The trial's court findings on this situation are subject to an abuse of discretion standard, and the court did not abuse its discretion. The undersigned's recollection is that at sidebar there was no request for a curative instruction, but rather a request to excuse the jury. The jury was excused. The member of the victim's family had either excused herself or by then excused herself. The allegations was then made that this was intentionally staged by the state. It was neither intentional nor is it uncommon, that a homicide survivor who has a right to be in the courtroom pursuant to Article 1, Section 16 of the Florida Constitution was mistaken in his or her belief about his or her ability to not become emotional during a trial. So the victim deliberately testified about DNA evidence on her buttocks belonging to the defendant when in fact that was not the conclusion of the DNA analysis, whose findings were inconclusive. I don't know. That they're talking about another case there. They're not talking about Sarah's. And then they're talking about Cullen versus State. It's distinguishable as it involves the mother of a sexual battery victim apparently needlessly being shown a picture of her daughter's vagina and throwing up in a trash can in the presence of the jury. And then there was another case where Smith versus State, where the medical examiner took a breath while testifying to the injuries the decedent had sustained and asked for a break. So they're saying this kind of stuff happens. People get emotional when they hear and see these types of things. So it's never been a cause for a mistrial or retrial for that matter. Just want to show you guys. We're still waiting on courthouse feed, so we'll go over there when it comes up. Okay, so the state understands the court's ruling at trial on the matter of whether Dr. Werner's, now we're talking about the psychological examination. The state understands the court's ruling at trial on the matter of whether Dr. Werner's opinion about the implicability of battered spouse syndrome evidence as a concept was a discovery violation and is not revisiting it for that purpose. Rather, the defendant has included this in her motion for a new trial, so the state will readdress it. The state is not required to disclose unrecorded oral statements unless it materially alters a prior written or recorded statement previously stated by the state to the defendant. Now, you guys, so basically what happened was, so they had the depositions for the doctor. She met with Sarah. She went, she spent time with her, whatever. She came back and she did kind of sort of, well, I say kind of sort of. She had a change of thought on some of this after looking at things further. And she told the state verbally that she had this change of mind in a way. Now, this defense is saying, well, you should have told us too. And the problem was is that the only reason she told the state was because they were just happened to be talking about the case while they were walking to the elevator. Literally is what I remember. Now, her response to that was, well, you didn't ask me. And that's true. The defense didn't come back and request information or any updated information when he had his round to question her. So this is on them. It's not on our witness. So the state deposed the defendant's expert, Dr. Julie Harper, as soon as possible after she was disclosed. The deposition occurred on October the 1st of 2024. Okay, now they're talking about Julie Harper, which was the defense's psychological evaluation. The very next day, Dr. Werner, who's the state's doctor, evaluated the defendant at the Orange County Jail at noon on October the 2nd of 2024. Given that trial was set to begin on October the 7th, this was less than ideal for the state. The state was not provided the materials that Dr. Harper had relied on at that time, although the defendant required much of them years earlier. The Dr. Harper's deposition had not been transcribed yet for Dr. Werner's review prior to the evaluation, and the second defense expert, Dr. Michael Brannon, had not been deposed yet. So this is a very good point. I didn't even think about this. So in addition to the other what we just talked about, they're basically bringing up a good point. You didn't provide everything to us that you were supposed to provide to us so that we could, because see, they're saying you didn't look at what Dr. Harper said when you evaluated. You should be reviewing Dr. Harper and Dr. Brannon's diagnosis as well before you give your evaluation in court. Well, apparently she didn't have it. After the defendant, in most material aspects, repeated her statements she made to Dr. Julie Harper that she zipped the victim in the suitcase and that they both initially thought it was funny, but she became angry after the victim stated he could not breathe. So she became violent with the victim and ultimately left him in there despite his stating he could not breathe and demonstrating his ability to get himself out of this predicament. It was Dr. Werner's conclusion that battered spouse syndrome evidence would be inapplicable. Again, Dr. Werner's the state's witness. Immediately after the evaluation on October the 2nd, both parties and the defendant went to court to argue the defendant's motion to suppress. October 3rd, the state began reviewing the prior interactions with law enforcement that Dr. Harper said she had relied upon during her deposition on October the 1st, and they arranged for body-worn camera and 911 calls to be provided to the defense team by ASA Dave Cacciatore on October 4th, while the undersigned was in Osceola County handling a placement hearing on a not guilty by reason of insanity first-degree murder case. Later, October the 3rd, the undersigned took the deposition of the second battered spouse expert listed by the defendant, Dr. Michael Brannon. Now, you guys, Dr. Brannon didn't really testify to exactly, or he didn't evaluate Sarah. He just got up and explained the whole battered spouse syndrome scenario and how it comes into play and everything. So he wasn't necessarily speaking specifically on Sarah. On October the 4th, immediately after concluding the insanity placement hearing in the morning, the defense took the deposition of Dr. Werner. Mr. Owens pressed Dr. Werner for any other opinions she may have had, and Dr. Werner insisted on being asked specific questions. This is not a discovery violation, nor the creation of a prior inconsistent statement. The victim's failure to mention the two incidents in response to defense's counsel open-ended deposition questions did not amount to a material change in testimony from the videotaped interview with Detective Martin's report, or the victim's deposition. Because the victim's unrecorded statement did not materially change her previous testimony, the trial court ended the inquiry and properly concluded that the state was not required to produce the statement to, I don't know how to say that, so I'm not going to pronounce that word. I don't know, y'all. I don't know. Wasn't me. This is indistinguishable from this case. Furthermore, the defendant was repeatedly placed on notice that the state did not believe, as a matter of law, that her statements taken in the light most favorable to her amounted to self-defense under Florida law. A discussion was held immediately following Dr. Werner's evaluation between the state and the defendant's lead counsel, to this effect when the defendant's lead counsel expressed that he believed the state should be lowering its offer of 15 years in the Department of Corrections because of what we had all just witnessed the defendant say. The state viewed the evaluation very differently and let the defendant's lead counsel know why. Further litigation ensued immediately thereafter on the defendant's motion to suppress the statements. The defendant in her motion states that the witness had formed a new opinion relating to what the defendant perceived an imminent threat at the time of the offense. This issue was discussed extensively in the expert witness's deposition taken on October the 4th of 2024. The word imminent does not appear in the entire 87-page deposition. It was not discussed. What the defendant stated on page 78 of Dr. Warner's deposition, according to Dr. Warner, was, and she said, I saw him in the suitcase and I zipped him up and we were laughing. She then said he said he couldn't breathe, and I remember feeling I couldn't breathe when he was choking me or sodomizing me, and I was angry and I shook the suitcase. I lost control of the suitcase and it flipped. Now, because she was never questioned on that opinion, there was no inconsistent statements to impeach Dr. Warner. Hypothetically, if the defendant had gotten Dr. Warner's opinion on this matter during the deposition, the state failed to see what the defendant could really have done about it other than disagree with it, because Dr. Warner's opinion did not violate Florida Statute 90.703, no more than when Dr. Harper rendering the opposite opinion. It was not an opinion on whether the defendant was guilty or not guilty. It was not even an opinion about whether the defendant used a justifiable use of deadly or non-deadly force. The opinion was about the applicability of battered spouse syndrome as a concept given what the defendant had told her in her evaluation. And that, because of what the defendant stated in the above paragraph, it was inapplicable even if the defendant suffered from battered spouse syndrome. It was no different than Dr. Harper stating that the defendant met the criteria for battered spouse, and the defendant telling her she was in an imminent fear at the time the defendant left the victim zipped shut in the suitcase. Experts can testify that a victim's injuries are consistent with forced sexual intercourse. And he says, experts also routinely testify about the applicability of the insanity defense to a defendant. Experts were routinely called to testify regarding the defendant's sanity in precisely these terms. Medical examiners routinely, as in this case, testify to the cause of death, and it does not invade the province of the jury. It is in opposite that the medical examiner's testimony contradicts the defense theory of the case. This is what happened here. Dr. Warner disagreed with the defendant. Because the defendant was examined by her own expert, Dr. Julie Harper, they complied with the rules, and the state had Dr. Warner examine her. Both experts were allowed to speak on the applicability of battered spouse syndrome regarding the facts of the case, and the relevancy of Dr. Warner was not listening to the testimony of Dr. Michael Brannon and Dr. Julie Harper is lost upon the state. I agree with that, because it's like she has the right to review it, but does she have to review it? No. And half the time it's like, well, is she going to agree with them? You're saying she has to look at it because she has to agree with them? No, that's the whole point in having separate doctors look at things. So that part just kind of, I don't know. Ultimately, regardless of what all three doctors in this case testified to, the crux of the entire case was that even accepting the defendant's trial testimony, which was largely consistent with her testimony to Dr. Harper's and Warner, she failed to comply with Florida Statute 776.041 and in fact escaped having the forcibility felony instructions read because of a statute of limitations technicality, a point which opposing counsel agreed with at the charge conference. This argument was permissible regardless of whether Dr. Warner testified or not. As a remedy, the court allowed the defendant to question Dr. Warner about opinions she was not asked about by the state to give to the jury, specifically whether the defendant. So they basically, guys, if you don't remember, they took the jury out and he questioned Dr. Warner again. James Owens did. And he kind of went over some things with her so that when he went to question her again with the jury in the courtroom, he knew exactly what was going to happen. So that's how they kind of fixed that whole situation. So they talk about what she said back to him, They're going to go over all this stuff here in a minute, you guys. Let me just go through this and see. I want to read this last part. It says the defendant was also allowed without objection to bolster Dr. Harper's testimony by reciting passages from Dr. Lenora Walker's treatise on battered spouse syndrome. This was accomplished by asking if Dr. Harper recognized the book as authoritative and then reading quotes from it. Likewise, without objection, the defendant cross-examined Dr. Warner with quotations from this treatise, with neither her nor the court recognizing the publication as authoritative. So that's their grounds on that. And hang on, let me look. Okay, still no court feed yet, you guys. The defendant, much like her motion to suppress statement cited, well, you know what? Let me refresh. Yeah, still no court feed. The defendant, much like her motion to suppress statement, cited no authority to support this ground being improper or grounds for a new trial. This, of course, is no bar to her again alleging prosecutorial misconduct. The proper limit of a rebuttal is a reply to what has been brought out in the defendant's argument. The state strategically broke up its closing arguments. The first argument was nearly entirely devoted to why the defendant was guilty of second-degree murder. Obviously, there is some inevitable crossing into why it was not justified and why the defendant lacked credibility, but that was largely left for rebuttal. The defendant's nearly 2-hour-long closing argument centered on why she met the criteria for battered spouse syndrome. It touched upon why this made it objectively reasonable for her to fear imminent harm or death if the victim escaped the suitcase. But they failed to address the applicability of Florida Statute 776.041 to the facts. And the facts were that she left the victim shut in the suitcase after he said he could not breathe and asked to be let out so that she could make him feel how he made her feel in the past. And she could not say whether she wanted him. And she could say whatever she wanted to him, and he had to listen to her. Sorry about that. It was completely fair rebuttal to distinguish the difference between a defendant's subjective belief that something is necessary versus objective reasonable for a cautious and prudent person in her circumstances. Likewise, it was fair to attack her credibility as a witness, and that was the foundation of her defense, and to point out that even if the defendant's arguments were accepted, she failed to comply with the statute. In conclusion, there is no right to jury nullification. The defendant was placed on notice several times that her version of events. Oh, we got courtroom feed. Yeah. I'm gonna leave that up, and then when they come on, I'll stop talking. But I'm almost at the end of this, so let me finish reading this to you guys. The defendant was placed on notice several times that her version of events did not amount to a justifiable use of force under the law. A, the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome, and the state's motion in limine, and the state's motion of examination by state expert, September 11th of 2024. B, the state's motion to strike defendant's amended notice of intent to rely on the battered spouse syndrome. And C, the state's motion in limine to exclude battered spouse syndrome or exclude mention of battered spouse syndrome evidence until the defendant testified to a justifiable use of deadly force. They give all the dates on these. And they say, and D, the state's request for forcible felony instruction and request for initial aggressor instruction on October the 24th. And C, the state's request for special jury instruction regarding withdrawing from physical contact on October the 24th. No version of the defendant's events amounted to a justifiable use of force due to her only stating that she became afraid after she had become angry and aggressed the victim by choosing to not let him out of the suitcase because he made her angry when he said that he could not breathe. She was going to make him feel like he had made her feel in the past, and she was going to say what she wanted to say to him while he was a captive audience. She admitted to what Florida statutes described as the forcible felony of aggravated assault. The Florida statutes, she was allowed her 10 days in court to ask for a jury nullification in the past the incidents of violence committed by the victim. The court should not grant a new trial. Okay. I hope I wasn't on mute for all that. Happy sentencing day, guys. Welcome in. All right, so what I just got through reading, if you came in late, that was the state's response to James Owens filing for a request for a new trial. And also, they've got a couple of items thrown up here on the docket that are closed because it's all about Sarah's psych evaluation. So, what we anticipate is going to happen this morning is they're going to be talking about some of that for a little bit before we get into the whole sentencing thing. In fact, it's going to be kind of an investigation they're going to do prior to sentencing. So, if any of you guys were with us last week when we were doing the trial for Susan Lawrence sentencing, they had a pre-sentence investigation thing they had to go over as well, and that thing lasted way longer than we all anticipated. So let's hope that this one does not. I don't think it's going to. It looks like they've got everything up on the docket. They're ready to rock and roll about this. But let me see what I've got a question here. Carrie, I don't understand of so-called experts. They want more money to fit Sarah's. I don't understand your question. Are you saying you don't understand these paid why the paid for play, like is what I like to call them, the paid for play attorneys, where the attorneys, they want them to say what they want them to say, kind of type of thing? Yeah. I mean, it happens. I don't know any other way to get around it. That being said, I mean, many doctors out there, they all disagree with each other in different diagnoses of patients. That's why they tell you, get another doctor's opinion. So, yeah, I think that there should be a lot of question put into some of these people that all they do is testify in cases. But at the same time, I don't know how much of that you can really bring into court and from the jury. So, all right, so let's talk about sentencing. What do we think is going to happen here, guys? I'm going to do a refresh real quick. Okay. Now, I'm wondering, before we get to the sentencing discussion, let me ask y'all something. Y'all remember when they had that whole thing about the defense getting paid based upon rights to Sarah's story and all that? And they even put a notice on the docket about how they thought it was shady and there was something going on there, and they never really truly addressed it in court. In fact, they said they were going to address it in the judge's chambers. Could that be what's going on right this moment? Could they be addressing that specific item in the judge's chambers? I wonder. So let me just check. I mean, we've got live feed in the courtroom. We're just waiting on them to come in. It's good to see everybody. Thanks for being here, you guys. I appreciate it. I've taken a little bit of time off since the trial and haven't been putting up that much. And I appreciate you guys sticking with me while I was doing that. Just needed to get some stuff done in my life before I moved forward with anything. Cass says, watch your language. Yes, the Pope's in the house. Pope's here. Netflix documentary with Owens interviewing. Oh, yeah. Amber Rachel. You guys, Amber Rachel is the one who has done these wonderful songs that you guys have heard on my channel. And, check the docket. Okay. And I just had to bring her up put her thing up there really quick because I wanted you guys to see who she was. And girl, I gotta talk to you because I would love for you to do some more for me, but I will definitely pay you for your time on this. I mean, she just did some amazing stuff. Those two songs are killer. Let's see. Okay, A Downward Departure. Oh no, that's the same thing they did with that they just put a up on the docket. Downward Departure. motion. Let me put this up really quick. I've Googled this before. So, a downward departure is when a judge imposes a sentence that is less severe than the sentence guidelines recommended for a criminal offense. Judges can usually use their discretion to impose a downward departure when they believe that the guidelines do not adequately address all circumstances of a case. Huh. Kranik's not going to do that. Kranik is not going to do that, you guys. he's, he's so ready to sentence her to life. Okay, it says this is, of course, this is filed by James Owens. He says that by and through counsel, Sarah Boone files this motion for downward departure, stating in support thereof the following: that the defendant was found guilty of the charge of second-degree murder on October the 25th, that the instant motion is filed pursuant to Florida Statute 921.0026, which lists statutory reasons to depart beneath the statutory guidelines. Just get to the point, Jamie. What do you want? The defendant asserts that she is eligible for a downward departure. The capacity of the defendant to appreciate the criminal nature of her actions and to conform said actions to the requirements of law was substantially impaired. Okay. If they're going there, they're saying she requires specialized treatment for a mental disorder that is not related to substance abuse or addiction and is amendable to treatment. They didn't put on a defense for her being, and they're saying that she was under extreme duress when the offense was committed in an unsophisticated manner, which was isolated and for which the defendant has shown remorse. She hasn't shown any remorse. Okay, number one, no remorse. Number two, it doesn't matter whether she had that or not. They didn't really bring that up in trial. They only said that she had some issues in her past or whatever. And then number three, if they're going to try to say something about her drinking, they can't do that because in Florida, that doesn't, if you were drinking and you did something, that's your own fault. You don't get out because of, oh, I was drunk, so oops, I messed up. No, you don't get that. But Amber Rachel, yes, to answer what you were saying, girl, if there's a Netflix documentary and they're interviewing people, I can guarantee you that any type of publicity that this trial gets afterwards, James Owen's going to be right in the middle of it. He's probably already got an agent that he's working with to get him booked on all these things. All right, so looking back here, I don't know if I see the family. Did y'all see the family in the gallery? I don't know if I saw it for dog mom's therapy. Does dog mom need therapy because she's got a hottie for cacciatore? I know that's her boo. Thank you, Mark, for your $10 super chat. I appreciate you. Appreciate you. And, oh, Donna Barkley. Carrie, love your channel. Thank you so much. You're so kind. It's very nice of you. And Laria, she's been a member for over 2 months, and she says, life without parole. Amen, sister. Preach. Oh, she's still smiling. What does she expect? See, y'all, you know what I think? I think that James has already talked to her, and he's made her feel like, oh, Sarah, we're going to get some of these charges taken off. Sarah, I've been working really hard. I've done the best I could. And we're going to get some of these charges broken down. Me and Margaret have been working on this for you. Woo! I wonder what they're watching on his phone. Looks like a video. Is he showing her his Thanksgiving holiday videos with the family? Or does it look more like writing? It looks like writing, like he's scrolling up and reading. They're reading something. He's showing her the document that they filed, I guess, or that the states filed, maybe in response. Oh, Laura, life without parole. Gentai always coming up with something funny. What's wrong, babies? You barely touched your Pop Tart. I love that. You're so funny. Cookie, resubscribed as a member. Thank you, Cookie. Thank you, darling. Route Iris, member for 2 months. Thank you, Route. Life, Sarah is a menace to society. Amen. Preach. Preach. I agree with you. Linger says, I have to imagine her utter lack of remorse or empathy for the victim, along with her changing story, has to come to into sentencing. That, Linger, and also the way that she acted throughout this whole trial, like she showed her ass, right? Throughout this whole process. I really believe that the judge has a right to bring all that information into sentencing. And you guys, am I wrong on that? If anybody knows for sure, tell me. I think I remember us touching on it a little bit, but that has to hold some kind of accountability. I mean, there has to be something there when he's doing sentencing about the way her writing those letters and all that, because that was just freaking ridiculous. Thank you for your super chat, Linger. Kate said, gift. Oh, thank you, Kate. Thank you for gifting a membership. I appreciate you doing that. And Miss Amber Rachel became a new member. Y'all go check out Amber Rachel's channel. She's got some stuff. She posts her songs up and stuff over on her channel, so go check her out too. Miss Janice. Hey, Miss Janice. We've missed you too. Life or close to that. I hope so. I hope so. Thank you for your super chat. I think they're going over what the state's response was. Looks like Sarah's got a new hair. Her hair trimmed a little bit again. Is it just me, or do y'all think so? We got volume. We got courtroom volume. So I don't know how long this pre-sentencing thing is going to last. I know that the last case that we had that something like that on, it was a 4-hour live stream. So we may be here for a little bit, you guys. Okay, there's the lead investigators right behind them. Yeah, there's George's brother all the way down at the end, but I don't see his mama. His mom's not there. His brother and his wife are there. And I don't know if that's Mo. We haven't seen Mo, have we? His other brother? There's Billy Lane down there at the bottom. James Owen says, this is it. After this, I don't have to deal with this woman no more. Billy Lane's thinking, geez, thank you, Jesus. I need all these. Oh my gosh, she's written a long statement, you guys. Oh, you know she's written a long statement. We know that she likes to talk. We have to listen to her give her pre-sentencing speech to the judge. I forgot about that. Now, it could be that they allow. I mean, they're probably going to allow victim impacts. I would assume that Juan Torres, George's brother, is going to speak, and I would assume that possibly the mom, maybe she'll come on via video or something. I don't know. Looks like she's got several pages there, you guys, ready to talk. Who are you looking for, Sarah? Nobody's there for you. It's all press. She's so gross. I'm sorry. Okay, let's see. Dog Mom has been a member for 6 months. Thank you, Dog Mom. Put your drool back in your mouth, Dog Mom, because I can see Cacciatore up in the far left-hand corner of the screen. Cookie says not to be outdone by Mark Leach. I love it. Oh, that's funny. Oh, you guys crack me up. I'm going to close some of these things up. Let's see. Heidi G says, thanks for all you do for us. You're so welcome. And thank you for being a longtime member. God bless you. Rebecca. Hey, Mama. Member for 2 months. Matthew. Hey, Matthew. Good to see you again. Life in solitary. We wish. Can you imagine being stuck in prison with Sarah? That would be a different type of prison. That would be like prison on top of prison. You know what I mean? These poor people have to deal with her. Wish anybody can anybody read lips? I wish I could read his lips. Judge must be in the room. Patty's been an OG member for 13 months. Girl, you are my people. I love being an OG, greatest group of people. Yes. I love my peoples. Y'all are my peoples. Thank y'all for being here. Love you, Miss Patty. I hope y'all all had a nice Thanksgiving. I think I'm going to change this. Let me see. Can I change the screen up? Let me see if I can do this before we start. Yeah, I can. A little bit. You can barely see me down there, though. Let me see if I can change the way I've got my setup real quick. If y'all don't mind, please hold. There, I like that better. I wonder if the judge is reviewing the documents that were just put up on the docket. If that's what the holdup is, because I mean it's 1:00 my time, which means they're already running 30 minutes late. I gotta look and see what kind of. I gotta see how long I've got on this stream because I'm on the non-paid thing now. I think I've only got 4 hours. I might have to pay for it. We'll see. They're being awfully quiet. Oh, I've got 5 hours. Okay, cool. I think we should be fine. They cut the audio in the courtroom again. All right, let me check out y'all's comments. What y'all talking about? What are y'all talking about over here? Emily H., remember for 1 month. What am I going to do with myself now that this is over? Emily, I've been doing the same thing, wondering myself, honey. I don't know. We're going to go into this crazy OnlyFans model trial next, which should be very interesting. She said, I will not, what? What could she possibly be talking to Billy about? Who can read lips? What is she saying, y'all? Thank you, Pam. Love watching your channel. Well, thank you. Thanks for being here. Yeah, good point, Amy. That in regards, I didn't think about that. Amy said in regards to that downward departure, she had an option to take the plea deal and she didn't do it. She could have gotten less. Hey, Drunky the Bear. Jolly old Saint Cray Nicholas presiding. Best ever. Best day ever. It was a good day. We're having such a good day. It's going to be a good day today, y'all. Yes, Twisty Quill Sarah looks pretty blasted rough, doesn't she? I'm trying to figure out, has anybody done any lip reading here? I feel her disapproving of me from here. Cass said, I feel her disapproving of me from here. Are you sure Sarah can't see us? Can you imagine having to live with her and be around her and how she would be just on an everyday basis. Oh, ooh, gross. Hobby Monster says she could store nuts in those cheeks. Amy, her bloated face. You know what I was noticing in one of those past um, videos from the body cam thing? I noticed her face looked really bloated, and I was wondering if that was because of drinking. Wait, is that his mom with the ponytail? Maybe she is. I don't know if I can't really see clearly if that's her in the middle there. That might be his mom there in the middle. She's hidden really well if it is. Is that a sign of alcoholism though when you're having the puffy face and everything? At my age, I wake up and I'm puffy looking, and it's like, oh, what happened? You'd think I got hit by a train or I'd actually had a rough night out or nothing. No, I just stayed up a little late. She doesn't look nervous. She doesn't look nervous because she always thinks that she's going to get something better than what like she always, I will give her that. She's very positive thinking. She's a very positive thinker. She believes that she's not guilty, so she thinks she's not going to get that much time. She probably thinks, you guys, think about it this way. She probably thinks that she's already spent 5 years in jail and he's going to let her go on time served. I bet that's what it is. What you want to bet? Oh, no, honey, that is not going to happen. If he sentences her to anything less than 20, I'll be pissed. What was the plea deal? The plea deal was 15, right? Pardon me, because I forgot already. Custer Girl said, will she start her speech with, well, I want to tell you who I am. I don't think you understand who I am. I excel at everything. Thank you, Cass. It was 15. 30 to life is my minimum to not scream. Okay, Amy. I'm with you on that. The minimum is 22.5. Okay, that's what I thought it was. See what happens when I go on a hiatus for a little bit and I come back, I forget everything. Yes, and she will say that it was unintentional, Cass. And Hobby Monster, she will say that she was a straight A student. If she brings up her school stuff, I'm I'm gonna fall out of my chair. There's no way she's gonna repeat herself. Hasn't she figured out that stuff is not working? She's an outstanding mother to her son. Mm-mm-mm. Yeah, I think you're right though, you guys. She is gonna say Hazy Harmony. She is going to go on and on about how it was an unintentional act and blah blah blah. Mark said, "I wonder how many license plates she can make in 22 years." Well, if she stops talking long enough to work, she might get a lot done. Yeah, she was just. Mm. Thank you, CB. She's been looking forward to this day for years. She can speak without being censored. She's excited. I'm telling you. I'm telling you now. Oh, that's funny. Here we go. We got full volume on. I'm going to go on mute now.
2020 CF 2603, state.
Chief Cacciatore on behalf of the state.
Defendants.
William J. for the state.
Defense.
James Owens for Sarah Boone.
Ms. Boone is seated at counsel's table. Ma'am, if you could please raise your right hand, Madam Clerk's going to go ahead and swear you in.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and the truth?
I do.
Ma'am, can you state your full name and date of birth for the record for us?
Sarah Boone, 10-10-7-7.
We are here for a sentencing. The jury returned a verdict on October 25, finding you, Ms. Boone, guilty of murder in the second degree. We are running a little bit late this afternoon. I apologize for that. I was in court all morning and took the opportunity to review all of your submittals from earlier this morning, Mr. Owens, including the victim or the character statements, the psychological evaluation by Dr. Harper, the motion for downward departure, the motion for new trial, and the state's response to same. Before we proceed with any sentencing in this matter, the court needs to address the defendant's motion for new trial and the state's response to the defendant's motion for new trial. Anything in addition you'd like to argue at this time, Mr. Owens, over and above what is contained in your motion, sir?
No, sir.
State.
No, sir.
All right. After reviewing the motion and the state's response to same, the defendant's motion for a new trial is denied. Based on the court's review of the record, the court's participation in the trial, and a review of all the evidence of the court's prior findings and rulings at trial and prior thereto. With that, I believe that we're prepared to proceed with sentencing at this time. The court has reviewed the pre-sentencing investigation prepared by the Department of Corrections. Are there any housekeeping matters that we need to address, Mr. J. or Mr. Cacciatore, before we proceed?
Not from the state.
Are there any housekeeping matters from your side of the ledger, sir, that we need to address, Mr. Owens?
Judge, I do have 4 lay witnesses that are going to testify. We've got Dr. Harper here to testify. Of course, my client's going to testify. But one of the 4 lay witnesses wants to appear by Zoom. She lives up in Minnesota. I don't know if that's allowed.
We don't have an objection to that. One of our witnesses will be providing an impact statement, would also like to appear on the court's virtual link as well.
Okay, so stipulated. If you need it, just let Anita know, and I could have her email it to you right now, the link.
We do have the link. She's waiting to get on, I guess.
Who might it be, sir? Several people.
It should be Lana Albert.
She is here, sir. She's in the, she's viewing, her camera's off and she's, microphone is muted, but she's in the lobby.
Okay.
All right, with that, state, you may proceed.
Your Honor, at this time, we would like to take an impact statement from, I believe, Anna Torres, which you will be appearing virtually.
I see several guests, but I do not see Anna Torres in the virtual lobby, sir.
Well, I think while maybe she's having some issue logging on, we have also in-person witnesses.
We can proceed with those first, sir.
His mama.
Please.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good afternoon. Could you state and spell your name for the record for us? Okay. Ma'am, you can go ahead.
I just want to tell Sarah Boone that I don't hate her for what she did. And I always remember that evening when that lady came into my door and she knocked at the door. And she asked for my name. I said, I tell her my name. And then she said, can I come in? I said, okay, yes. And she told me to sit down. I never think that that was gonna be my son. And then she said my son was dead. Since that day, I can't sleep. It's hard for me to remember that moment. My son is not here no more. She don't only kill my son, she killed a father, a brother, an uncle. It's been hard. And my family, because all the brothers, they will always work together. But now it's like something real. Love is missing. Sometimes when I look out the window, I wait for him to come and say, Mom, I love you. She was always there. She come and call me. I miss that mommy. The last time that I talked to him was at 12 o'clock in January, New Year. He came to my bed and said, Mom. He woke me up and I said, Mom, I love you. Happy New Year. Since that day, I don't see him no more. He was my son. I love him. And I miss him a lot, and my family miss him a lot too. But I don't hurt her. But you know what? I was blessed. She ain't gonna be blessed like me because I have my son. I raise him. I have his children, my granddaughter, my grandson, and she don't gonna be able to have that. And I did. I raised him. He wasn't perfect, but he was a good son. Thank you.
Thank you, ma'am. State anything further from this witness?
No, Your Honor.
Defense?
No, sir.
Thank you. You may call your next victim impact statement.
Victoria Torres.
I do.
Ma'am, could you state and spell your name for the record for us, please?
Victoria Torres. My name is Victoria Torres. George is my brother.
Oh, that's his sister.
Unfortunately, my family has experienced two horrifying tragedies. I just want to make it clear that George deserves justice. As far as my other brother and Sarah deserve to rot in jail. Sarah has caused a lifetime of pain, a lifetime of horrible images, a lifetime of hearing my brother George plead for his life. This is just this moment for all of you. For me and my family, it's forever. Such a simple thing as using a suitcase is so triggering. I try not to close it all the way. I leave at least like 2 or 3 inches for the zipper. And it might sound crazy, but it just helps me. She really has flipped my family's life upside down. And I just hope that we can truly get justice for my brother. And I just want to tell the team, thank you so much for everything they did. Thank you.
Thank you. State anything further?
No, Your Honor.
Defense?
Yes.
Thank you.
Your Honor, could we see if Ms. Anna Torres has been able to make it online?
Do not see an Anna Torres in the lobby, sir. I have lots of guests, HHSA, Mr. Beck, Lana Albert, Jason Gunn.
Now I know who Sarah was scared of. It wasn't the brothers.
Link as to the number of individuals.
Not to my knowledge.
It was Victoria.
Just a moment.
Yes.
I would have loved to have seen Victoria get a hold of Sarah. Is that his daughters that they're waiting on, I'm thinking? It's got to be. Wait, his Cookie. It was Cookie. Anna is his daughter. Okay, thank you, Pope. I couldn't remember the other daughter's name. There's 3 of them, right? Is there 3? No, there's 2 daughters and 1 boy, 1 son. Thank you for reminding me, Kova. Yes, it's Destiny. You're right. Okay. I think it's very telling to the judge that the family has not shown any kind of, I wouldn't say ill will. That's not the proper word, but like there hasn't been this, Sarah makes it out to be where she's so terrified of this family that they're just going to get to her and all this and that. That's not at all what comes across here in the courtroom whatsoever. And the judge is going to see that and he's going to remember that. I wonder about that, Tracy. I wonder how much they let that stuff impact them, like as far as the statements and stuff. This last judge that we heard from said that they didn't even, like, when somebody gets up and has, what do they call it? I can't think of the word. When someone gets up and speaks on their behalf, as far as their personality and all that. What do you call that? Oh, God, I'm at a loss of words right now. I can't imagine like him letting anybody affect what he thinks of her. Character witness. That's what the word I'm looking for. Character witness. To talk about, her as a person or whatever. So yeah, I think he's probably already got it in his head, and there's probably not a whole lot that could sway a judge when they've got that already ready to rock and roll. You know what I mean? Thank you, Blanco, for being a member for 13 months. I'm Cookie. I can't put that up, Cookie.
Yes, sir, Mr. Cacciatore.
Your Honor, after speaking with Mr. Owens, given the fact that the victim's daughter is having difficulties with
Is that her, Anna Victoria Torres?
Yes, sir.
There she is.
Is that it? Is that who it is? All right, ma'am, good afternoon. Can you hear us?
Good afternoon. I can hear you.
Okay, could you please state and spell your name for the record?
My name is Anna Victoria Torres, ANAVICTORIATORRES.
Thank you, ma'am. I understand that you'd like to provide a statement to the court at this time. You may proceed.
Okay. Okay. So I'll be speaking for myself and my two siblings. The murder of our father has impacted us on so many levels and in different ways. I myself, for the first year, would wake up screaming every morning or night, wishing I was having a nightmare, only to wake up to remember all over again that my father is gone and I'll never be able to hear him say he loves me ever again. To know my siblings have been affected in such a way that they are now different. They have had a piece of their heart ripped away from them, all while her son gets to hear his mother's voice and see her alive is pathetic. Because of you, Sarah, my sister is heartbroken. Because of you, Sarah, my brother is left wondering when he will ever see his father again. The loss of my father has left me with chronic depression and anxiety. Seeing any moments of fatherly love or kindness being shown between others in real life or even on TV leaves me in complete shambles. Seeking therapy was a must in order to navigate through my workday without a random breakdown. Thoughts of my father's demise still enter my mind ever so often. I'm left either angry, sad, or sick to my stomach to think of how his final moments were. George Torres, my incredible father. Not only was he my father, but my best friend. My personal comic provided me with wisdom and knowledge, creative and loving dad, an older brother, an uncle, a cousin, a friend, a son, and above all, our father. He was human and deserved to be treated as such. My father, George Torres, was one of a kind, an absolute gem. Unfortunately, his light was dimmed on earth by evilness, but with us, we will forever make his name live on. Especially Sarah, I pray that you see his face when you see him at night. That is it.
Thank you. Anything further, state?
No, Your Honor.
Anything further of this witness?
No, sir.
All right, thank you, ma'am. State.
Thank you.
Anything further?
No other impact statements, Your Honor.
Thank you.
Thank you,
Any other
Barbara.
witnesses or evidence at this point in time, state?
No, Your Honor.
All right, Mr. Owens, you may proceed, sir.
Ms. Diane Smith. Judge, what do you want?
I have no issue with her being at the podium. If you want to move about the well to conduct your examination, that's fine, counselor. Ma'am, come on up. Come on up to this podium right here, ma'am. If you could, raise your right hand. Madam Clerk's going to go ahead and swear you in.
You solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but truth? I do.
Ma'am, could you state and spell your name for the record for us, please?
Diane Smith, DIANESMITH.
Okay, thank you very much. Counselor, you may inquire.
And Ms. Smith, tell the court a little bit about you.
I was a chaplain at the 33rd Street Jail for 30 years.
And have you been a chaplain at the jail here in Orange County?
Yes, Orange County Jail
Is that the same
for
jail
30
you're
years.
referring to? Okay. And during that period of time, did you have occasion to meet with Sarah Boone?
I did.
And was it over the course of how long?
I've known her 4 years.
And if you could, tell the court what you'd like to say.
Okay. Well, I first met Sarah. She came in. We have a Christian dorm, and Sarah enrolled in our Christian program. and she was in my classes for a year. And she was very sincere in her efforts to change her life and to be a better person. And I found her very helpful. She was kind and good to people. She loved to serve. And she helped the new girls that would come in, the younger girls. She would mother them, be very kind and very helpful. And then after she graduated from the program, I was her counselor for the other 3 years. And I always found her, very sincere and, trying to do better. I spoke with many inmates that knew her and was associated with her. And they spoke very highly of her and said that, she was helpful and kind and tried to help other people. And I just found her to be, very sincere and trying to be a very good person and change and help people.
Was the Bible involved at all?
Oh, yes, it was all spiritual. Yes, it was spiritual growth plus character, growth and character, trying to just be a better person in general. She liked to serve other people, she would help the girls wash their clothes and show them around and teach. But spiritually, she grew very, very great spiritually.
Thank you.
Hang on, ma'am, just 1 second.
Ma'am?
Hang on just 1 second, Ms. Smith. State any questions.
No, Your Honor.
All right. Thank you, ma'am. I appreciate you.
Thank you, Pascaline, for your
If I could
super
call,
chat.
Christina Pena.
Yeah, it's fine, Counselor. Thank you. Ma'am, come on up if you can. Raise your right hand. Madam Clerk's going to go ahead and swear you in.
solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth.
Ma'am, if you could state and spell your name for the record for us.
Christina Pena, Christina Pena.
All right, you may inquire, sir.
Ms. Pena, how old are you?
31,
And where do you live?
Orlando.
Now, it's my understanding, Ms. Pena, that you were in the county jail with Sarah Boone. How long were y'all in the same cell together?
Yes, I was in there for 4 years, but we're together for 3.
Okay. And I understand ultimately the charges against you were dismissed? And so you were released on what day?
April 4th this year.
2024?
2023.
2023. So you've been out for a pretty while.
I've been out for like 6 or so months now. Yeah, since April
Okay.
of this year, actually. Sorry.
April of 2024. And you said y'all were bunkmates there together for about 3 years?
Yeah.
I would assume that y'all got to know each other pretty well.
We did.
And if you'd like to speak on her behalf to the judge.
Sarah's one of my best friends, my only.
Take your time.
She's helped me a lot. Spiritually and like growing and she helps everybody. She's always, I don't know, spirit. She helped me a lot and she would come to me. She talked to me all the time and pick me up when I was down or if I didn't know something. She just good. I don't know. She was a good person to me. She just, mistakes happen. She always helped. She always helped people. She was always helping everybody in the dorm. She, even like her artwork, she did art. Anybody need any help or needed anything, they'd come to her and she'd help them. Even if they, did wrong to her, she would still go back and help them and praise with them and pray over them and everything. It's just.
And was she a little bit older than you?
Yeah.
How much older was she?
40 in her 40s.
Did you think of her as maybe an aunt or a big sister?
A big sister, yeah. She was like a big sister. It's like a sister I never had. Because I have brothers, so I never, we clicked right away. I don't know. We'd be walking out in the backyard and she just would always try and talk to me, but I'm a quiet person and I don't trust a lot of people. So for me to open up and trust somebody, it's a lot. So.
And obviously y'all are there under difficult circumstances.
Yeah.
She assists you in getting through that.
Yes, and she helped me a lot with my my case, and I would help her with with hers too. We're both. Justice is not what it is. I don't know how.
Bless you.
We both helped each other out. I don't know.
Ms. Manuel, I appreciate it. Thank you.
Any questions, State?
No, Your
All
Honor.
right, thank you, ma'am. I appreciate you.
Ms. Hill? Judge,
Yes, sir.
after Ms. Hill, I want to thank Ms. Albert.
Yes, sir.
Please raise your right hand. Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Ma'am, good afternoon. Could you state and spell your name for the record for us?
My name is Mariela Hill, Mariela, last name Hill, Hill.
Thank you. You may proceed, sir.
Ms. Hill, briefly tell us a little bit about yourself.
I met Sarah in jail. I spent 3 months in jail and went through a lot of unfortunate circumstances myself.
All right, now this was in the Orange County Jail here in Orlando?
Orange County Jail.
And when would that have been? Do you recall the dates?
Yes, it was April, from April to June of this year.
Of this year,
2024,
2024.
correct.
Okay.
Yes.
And did you develop a relationship with Sarah Boone over the course of that 3 months?
Yes, yes. We met when I was moved to the B dorm, and I needed help with a form that I needed to complete, and one of the COs pointed to Sarah to help me out. And since that moment, we became really good friends, and she was so helpful, so kind, so respectful, and loving, not just to me, but to everyone. And I have nothing but good things to say about her character, her loving heart, and how deep her faith is, her faith in God and believing in justice for everyone. That's what I believe.
State any questions?
No, Your Honor.
All right, thank you, Ms. Hill. I appreciate it. Ms. Albert, good afternoon, ma'am. Can you hear me? This is Judge Kranick, and if you can, I would ask you to turn on your camera and unmute yourself at this time, please.
Sir, how do I unmute turn on my camera? I know how to unmute, but I'm not sure how to turn the camera on.
Turn the volume down.
So, ma'am,
Is that better?
When you join the link, there should have been an option for like a pull down on the left-hand side of the screen for you to open out or turn on a camera. I don't know what device you're appearing on, if it's a cell phone or a laptop.
It is an iPhone. Should I try to re-enter the room?
Yeah, try to do that. There should be an option for you to pick a camera. You'll either select the default camera and hopefully we'll be able to see you at that time.
Okay, let me just give me 1 second.
Sure.
These are all cellmates. Obviously, it's not the cellmates that she ratted on. No, I don't think that prison witnesses count for a whole lot. I really don't. Not to say that they should, but that they shouldn't, but. And they talk about her finding God and all that. Well, she didn't find God before she wrote all them letters. If she had God, she wouldn't have written those letters that she wrote that had full of so much hate to everybody in the court system. You don't have God in your heart and talk like that.
Did that work? Can you see me?
Nope.
I cannot.
Shoot. Yeah, it's saying default camera. It's saying front camera. I chose it. It didn't show my face or anything like that.
Margaret took a hard pass on that one, Mark.
State?
I have no objection to the witness taking the statement here.
Okay, appreciate it. All right, Miss Albert, good afternoon. If you could just state and spell your name for the record for us, please.
Certainly. Lana, Lana, Albert, Albert.
Okay. All right, Mr. Owens is going to ask you some questions. And if you could just answer them, ma'am, I would greatly appreciate it. Sir, you can proceed.
Miss Albert, do you have the ability to turn your volume down?
Yes, I just did. I can't hear you very well when I do that, though.
You can't hear me?
I can hear you, but very, very quietly.
How about now?
Yes, I can hear you. Am I okay?
Yeah, you sound a lot better. You were too loud earlier.
Okay.
Can you hear me okay?
I can hear you.
All right, Miss Albert, tell the court a little bit about yourself briefly.
Well, I live in Minnesota. I currently have end-stage renal disease. Before I became disabled, I was a business owner in the Twin Cities here.
All right, and how old are you?
I am 50 years old.
All right, and you're considered disabled?
Yes, I am.
All right, and have you had an occasion since this event to establish a relationship with Sarah Boone?
Yes, I have. We have been friends for the past a little over 11 months.
And how do y'all communicate?
We've communicated a lot of phone calls, lots of tablet back and forth, and a lot of letters as well. I'd say many, many, many hours of time spent with each other.
All right, and do you want to speak on her behalf here today?
I would, please.
All right, would you please tell the court what you would like for the court to know?
Thank you very much. And thank you very much, Your Honor, for the privilege of speaking on behalf of my friend, Sarah Boone. I also want to extend my heartfelt condolences to everyone here affected by this terrible tragedy, which has brought us all here and listening in. Many, many articles and videos and opinions of Sarah have gone out in the airways and on the webs. Opinions that have been formed and commented on so much that it's hard not to give into the temptation to treat people like a comic book or a fictional character. In the case of my friend Sarah, the words narcissist, Karen, villain, many other things, they roll off the tongue with little regard to the humanity that is dismissed so flippantly. And under a lot of circumstances, I was one of those people, as I have a love of true crime. And becoming friends with Sarah has shown me that there's a lot more depth to the people I see on the screen. I'd like to share with the world and with the court about the Sarah Boone that I know. Sarah Boone is a kind, honest, and good person. The Sarah Boone I know is one who loves animals, especially the kind who are damaged and defenseless. How many of us would take in and pour love for a hearing impaired and a sight impaired pair of dogs? She has a natural instinct to help reach out and give of herself, her time and energy and love, especially to those who are hurting or damaged. You all have seen her fight for her own life and truth here. I tell you this, she fights even harder for those she loves, giving time, attention, and companionship without a single thought for her own gain or what somebody can do for her. And one huge example is in the matter of our friendship. As I said before, I have end-stage renal disease caused by a genetic illness called polycystic kidney disease. As my life has progressed, things I have taken for granted have been taken away from me. I could not appear in court in person because I can no longer walk, as my dialysis treatments have affected the circulation of my legs and has confined me to a wheelchair. To say that my life has radically changed is an understatement. Through it all, I have many friends and family I love and cherish. Sarah has distinguished herself differently in this way. In the course of getting to know her, I started sharing the progressing state of my health. It was like lightning had struck her. The moment Sarah had learned the depth of my struggles health-wise, she straight up offered strenuously to donate a kidney to me. I got to tell you this. I hope she's not mad for me showing this, but she had no hesitation, no concern over personal risk or personal gain. I want to convey to this. out and around the world that is merely offering is a good and heroic act. I've had many friends. I've not had one outside of my brother who has offered me a kidney. That is huge. I don't have anything of equal value to give to her. And that's not the actions of a narcissist. She did it as a reflex action, as a good person. After the verdict came in October, we spoke that night. And I hope Sarah doesn't get mad at me again for disclosing this, but out of all the shock and seriousness of what had happened in the court, the thing that made her emotionally break was that she realized she could no longer be a donor to me. I mean, I was sitting there like, hey, you know, it's going to be okay. But she was so broken up, she couldn't help me. That's a friend. She is not, nor does she come up anywhere remotely close to being a narcissist. And one more thing before I go. Social media has worked to rip the blindfold off of Lady Justice, to take the sword out of her right hand and start assassinating Sarah's character. However, the scales are the balance. As it says in Psalm 85, mercy and truth are met together. Righteousness and peace have kissed each other. Justice isn't justice without mercy. Our pursuit of righteousness isn't complete and right without peace. Thank you, Your Honor, for the honor of speaking for my friend Sarah Boone. I hope that your justice is mixed with mercy here today. Thank you.
State, any questions? No, Your Honor. Any follow-up, Mr. Owens?
No, Judge.
All right. Thank you, Ms. Albert. I appreciate you.
I'd like to call Dr. Harper. You want her on the stand or?
I'm okay with her on the stand.
On the stand?
No, she can be right now. Yes, sir.
Be right with you. Yes, sir. I don't see Kevin.
Oh, the Harper that got everything wrong and doesn't really know Sarah at all? That Harper? There she is.
Doctor, good afternoon. If you could please raise your right hand. Madam Clerk's going to go ahead and swear you in. If you could, doctor, state and spell your name for the record for us, please.
Dr. Julie Harper, Julieharper.
All right, thank you. Counselor, you may inquire.
And Dr. Harper, we all know we were here a few weeks back for the trial, and your testimony, so the judge knows quite a bit about your testimony. But if you could, I know that you prepared a report, and we have submitted that to the court, which the court has read, and the state has a copy. And I don't know if you want to refer to that or just speak on wrong about Sarah Boone and what you did to assess her and any opinions that you want to express.
All right. I think that during trial testimony, I reviewed all of the documents, excuse me, and all of the records that were available. They're documented in my report as well. In addition to the forensic clinical interviews that I conducted, I also have had the opportunity to talk to her brother, Philip Paulson, in the interim since the trial, and I included his information in my report as to her family background.
If you could, give the court a synopsis of what your findings are, or what you recovered maybe from the brother, whatever you think the court needs to hear this relevant material to his decision.
So referring to the summary section of my report, I'll keep it a brief, but I'll outline the highlights that I feel like haven't been conveyed before, which is an understanding of Ms. Boone's early family life, in that she is the middle child of her parents' union, and that her parents did not have a happy marriage. They didn't provide an opportunity to have a good role model as to how to have a partnership together. Ms. Boone was born in close proximity to her youngest brother, 11 months apart. And in my clinical experience and training, I would say that that disrupted her attachment with her mother, some being close in proximity with her younger brother, whose temperament just seemed to suit a relationship with her mother better than her own. So ultimately, Ms. Boone bonded with her father, though he wasn't described by either child as an affectionate person. He was somebody that was there for her at sporting events and more of a primary parent for her in that way. His untimely death by heart attack during her high school years was marked by her brother as a turning point for her in how she was acting at home. Her demeanor, her relationship with her mother took a turn for the worse as she was not coping well. She was using substances based on what her brother was saying. And it is my opinion that that early lack of foundational relations with her mom and not feeling very secure, the death of her father, destabilized her. That's a period of your life when you're leaving high school, when you should have formed a very solid foundation to go out in the world. And I don't think that that's what she had at that moment. She bonded easily with Mr. Boone, and you can see that there are elements of that early difficulty with her relationships because she took on a parentified role, in my opinion, during that relationship. And therefore, there's a power imbalance in that she was making decisions and not, again, having an equal relationship. I think that that led her to a sense of being a need to be right, a need to feel like she is the one that's making good decisions, to have some ego support by being in the right all the time with Mr. Boone. And I think that that led to some behaviors that she carried over into her relationship with Mr. Torres, in that she's parentified around him and acting more like a parent-child relationship, being a facilitator of housing and applications for jobs and things like that. So again, there's a power imbalance that I think was very seriously misaligned as her brother and the property manager of their apartment had verified they saw her being abused, physically abused in serious ways, or the effects of the abuse in bruising or calls to them. It is my opinion that she called for help, but when people got tired of her not leaving Mr. Torres, they stopped responding to those calls. And basically, Ms. Boone handled things on her own. And as other people with healthier boundaries probably would have left, she being acting out the pattern of intimate partner violence did not leave. She stayed long past when it would have been smart for others, or others would have said to leave, sorry. The undergirding of that not leaving the relationship is a long-term anxiety problem that became post-traumatic stress disorder. There is an earlier instance of exposure to traumatic stress in that she was the person in the hospital after her father died who found him having students perform CPR on his dead body. So that was an early exposure to high traumatic stress, witnessing that incident, and based on her brother's description, that was something that changed her. When a person is exposed to numerous compounding stressors, their adrenaline system is changed. It alters your body. And things that might be an otherwise neutral situation, you tend to have a cascading adrenaline response to that. And I think that that ultimately for her, as she succumbed to other instances of serious physical abuse from her partner, became post-traumatic stress disorder. I do think that that is a condition that is still existent even while she's in jail. It's something that she needs treatment for because those triggers are unmitigated, meaning that she hasn't really had the kind of therapy to address them and reduce her adrenaline and anxiety responses when she thinks of past instances of traumatic events that have happened to her. You can also respond to post-traumatic stress disorder clinically by using antidepressant therapy, and that would be something that could assist her ultimately in reducing symptoms if she had counseling and antidepressant therapy.
Now, Dr. Harper, I know you testified in trial that, in your opinion, she suffered as a married spouse. syndrome that is legally recognized in Florida, in the courts of Florida.
That's correct.
And I understand that is tied to this intimate partner violence, which is maybe the same thing, but there's a complex mental health issue that ties into that. Can you speak on the complexity of that whole cycle that one such as Sarah Boone and George Torres were involved in?
Certainly. So intimate partner violence is not a diagnosis. It's a pattern of events that occur between two partners in which the power dynamic is altered by the physical abuse or behaviors that are controlling in nature to the point that someone's safety is threatened. It's common for victims of that to have a complex mental health condition, often including depression, anxiety, and substance abuse problems. And what might be substance abuse to cope with the problem, like numbing oneself, will sometimes result in its own diagnosis. The pattern of intimate partner violence, I think we covered in the trial, but just in summary about that, there are phases in which at first bonding of the two partners might be something positive. They've got something in common or have pleasurable time together. And then the secondary phase of that is when there is change in dynamic and some kind of traumatic event occurs, some instance of physical violence. And then there's a third phase in which it's like a honeymoon phase where they're trying to right the relationship. So in phase one, when they're having something pleasurable, the tone shifts. Phase two, there is some kind of incident. And phase three, there's a honeymoon phase. As that pertains to anxiety, I think that a person who suffers from intimate partner violence never stops experiencing that hypervigilance, waiting for the next instance of violence to occur. So even though they may look happy, they might be experiencing something positive, they've not really relaxed because their memory that could or will occur again is still in their mind. So they haven't fully stopped experiencing intimate partner violence. It's just what phase of the process they're in.
No, and Dr. Harper, it goes into more detail in your report, which I supplied to the court, which is total of 11 pages, and I believe that's confidential documents.
That's what's been marked. I don't believe it's been filed in the court file.
Okay.
If it has, that's something if it needs to be, it's something we can address. I have reviewed it. It does reflect confidential privilege information on the first page. I don't believe it's been filed in the court file unless you did it. Okay. It already has been? All right, appreciate it. Excellent. Thank you, sir.
And Dr. Harper, you're aware that the defense has filed a defendant's motion for downward departure.
Yes.
And we've listed several factors under paragraph 3, the capacity of the defendant to appreciate the criminal nature of her actions and conform with requirements of law or substantially impaired, that she requires specialized treatment for a mental disorder that is not related to substance use or addiction, although you agree that she does suffer from alcohol use disorder.
So she has an underlying mental health disorder, post-traumatic stress disorder, and I additionally diagnosed her with alcohol use disorder, which is separate.
But you agree she does require specialized treatment for a mental disorder that's not related to the substance abuse or addiction?
That's correct.
And you agree that she's amenable for treatment?
Yes.
And you would agree that she acted under extreme duress in this unique homicide case?
Yes.
And you would agree that the uniqueness of the circumstances, the facts and circumstances surrounding the case, that the offense was committed in an unsophisticated manner?
Yes.
It was isolated.
That's my understanding as well.
Other than she had the charge, which both of them were charged at one time, and I think she had the strangulation allegation, the felony case that was ultimately dismissed when both of them were arrested.
She had a prior felony case, facts are different, of course, than this particular case we're here today.
Dr. Harper, I believe that's all the questions I've got, unless you would like to say, if I've missed anything, of course.
No,
Okay, and if not, it's in the report.
yes.
Any questions?
Yes, if she takes a stand so I can be quoted.
Yes, that's fine. sir.
In pages 1 and 2 of your report, you go through the sources of your information, correct?
Yes.
And that would include 8 interviews that you had with her in the course of August of 2020 through September of 2024, correct?
There were 9 interviews, but 8 dates of service are listed.
You did the Miller Forensic Assessment of Symptoms Test, or MFAST.
That's right.
Inventory of Legal Knowledge, ILK.
That's right.
Clinician Administered PTSD Scale 5 examination.
Yes.
You consulted with her attorney.
Yes.
Videotaped interviews from this court case number of Sarah Boone, interview part 1 and 2, Abraham Moreno interview, Brandon Moats interview, Brian Boone interview, Juan Torres interview, and Melissa Sexton interview, correct?
Yes.
You reviewed the autopsy photos.
Yes.
You reviewed some of the digital forensic exhibits, including the Apple iPhone XS and a Samsung SMJ 327 T1 photographs from those 2 devices.
Yes.
You reviewed Bates stamped discovery pages 1 through 413.
That's correct.
The crime scene photos are photos of a scene taken on June 19th of 2020.
Yes.
Aspire Health records.
Yes.
And who do those pertain to?
Aspire Health records are for Sarah Boone.
Florida Hospital Medical Group records.
Yes.
And who do those records pertain to?
That is also for Sarah Boone.
And Aspire, is that a mental health treatment facility?
It has an emergency department record, but that would be the place where she was detained under the Baker Act.
And it is routine and common in the practice of forensic psychology or psychiatry to rely on the records of other such practitioners.
As a source of information, sure.
You reviewed the deposition of Dr. Tanya Warner.
I did.
You reviewed the trial testimony of Sarah Boone, Brian Boone, Dr. Michael Brannon, Dr. Tanya Werner, correct?
Yes.
The jury verdict form dated 10/25/24.
Yes.
Witness list notice of filing amended
Yes.
on this case. Records of Jorge Torres or George Torres involving case numbers 2019 MM 5114, a 911 call and PDF, case 2019 MM 7193, case 2019 MM 7193, Torres Public Records, case 2019 MM 7193, Torres Photos, Central Florida Primary Care Records, Advent Health Orlando Medical Records, correct?
Yes.
And those latter records that I just mentioned, those for Mr. Torres and not Ms. Boone, correct?
That's right.
Then you reviewed Sarah Boone written correspondence, Sarah's listing of domestic violence incidents, Sarah's writings regarding missing days of work and Baker Act, and a 74-page life story.
That's right.
And then case 2018 CF 10573, public records and photos.
Yes.
And a telephone interview with Melissa Sexton, the property manager, which you conducted on October 1st, 2024.
Yes.
And a telephonic interview with Philip Paulson, the defendant's brother, on November 26, 2024.
Yes.
Where has Ms. Boone been housed and living since February of 2020?
At the Orange County Jail.
And does the Orange County Jail provide mental health services to inmates?
It does.
And you already testified you would routinely, as a forensic psychologist, review records kept of a psychological or psychiatric treatment of a patient or a client, correct?
Yes.
In this particular case, have you reviewed any mental health records generated by the Orange County Jail for Ms. Boone?
No, I have not had the opportunity to do that.
So for the last 58 months or so, if she was being seen by the mental health treatment staff at the jail, you have not reviewed those records.
That's correct.
And they are overseen at the jail, in the Orange County Jail, by a psychiatrist. Are you aware or not?
If the person's level of mental health intervention deems them eligible for psychiatry, then they will.
And any diagnosis or lack of diagnosis that they have had during the course of the last 58 months, you are unaware of because you did not review the records.
That's right.
I don't have any other questions.
Any redirect examination?
No.
No, Judge. All right, thank you.
One question. Dr. Harper, I didn't ask you to review those records, did I?
No.
Thank you.
Judge, I believe you said it at the very beginning that I had submitted several letters on behalf of Ms. Boone, and she didn't hear that, but I wanted her to be made aware.
Yes, ma'am.
And that you don't actually read those letters into the record, but you did read them.
I have reviewed them. They're in my binder here.
I.e., she doesn't believe
How many
me.
do I have? Yes. Give me a second. I can tell you.
Can you please
I have
confirm that I did that?
I have 6 handwritten letters. First one is 1 page. Second one is 2 pages. Third one is 1 page. Fourth one is 2 pages. Fifth one is 2 pages. Sixth one is 2 pages. I have a typed letter from Diane Smith, the assistant chaplain. I have another typed letter from a Nicole Ray, a typed letter from a Stephanie L., a typed letter from Philip Paulson, a email from Lana Albert, 2 pages in length, and a 2-page email from a Danielle Parsons.
Thank you.
Yes, sir.
Judge, I would like to call Sarah Boone.
You may proceed.
If you could take this.
Yes, please.
Here comes the show, guys. Her last opportunity to make try to make a joke out of the court system.
Ms. Boone, you can be seated. You've been previously sworn. You may inquire, sir.
For the record, just state your name again.
Sarah Boone.
Now, this is unlike a trial, so you're allowed to speak in a narrative form, as well as I understand you have taken some notes or written a letter that you want to read from, and then you want to speak to the court after that.
Yes.
Why don't you go ahead and get started?
This is actually an edited version of. I had a lot to say. I've had a lot of time to think about things, and I didn't really know how to put it on paper. And I didn't know how much I could say or how little I should say. So what I have here is, like I said, an edited version. But I would like to read the more important parts that I feel that everyone should know that wasn't said in my actual trial. And on top of what I have on paper, this is just the tip of the tip of the tip of the iceberg. So I wanted to read this, and then if I may, I would like to address everyone in my apology on top of my statement.
You may proceed, ma'am.
Kintu Sukuroi is a kind of Japanese ceramic style which means to repair with gold. In this tradition, when a ceramic piece breaks, an artisan will fuse the pieces back together again using liquid gold or gold dust lacquer. So rather than being covered up, the breaks become more obvious and a brilliant new piece of art emerges from the brokenness. It embraces flaws, weakness, and imperfections, and also teaches the essence of resilience. Every crack in a ceramic piece is a part of its history, and each piece becomes more beautiful because it has been broken. This is the wisdom of Kintu Sukuroi. In my wisdom and with all of my repairs, then, now, and ongoing, God is, has been, and will always be my artisan. All of my gold is forgiveness. This has held me together, made me shine brighter, and overcome the damage caused by George Torres, the Torres family, the justice system, Orange County Corrections Department, social media, scoundrel detectives, infamy, defamation, ongoing constitutional rights violations, second-degree murder, forced into being pro se. Just as gold is very precious, forgiveness is invaluable. Forgiveness is not an attempt to change or forget who, what, or how you've lived through to be so gold, but an act of grace, humility, and considerable self-compassion to be set free from sorrow. Withholding forgiveness denies your brilliance and adds even greater grief and deeper heartache, irreparable cracks on top of the already that no one deserves, no matter the pain or disappointment, untruths or injustice. It doesn't matter, as the more broken you are, even though now different than before, you've become more outstanding and more extraordinary. Above all, when you let go of blame, misunderstandings, excuses, give up your anger and cease from resentment, this is forgiven. And when you forgive, you heal. And when you heal, you move forward. My goal begins with George Torres, and every time he slapped me, kicked, punched, spit on, raped, stabbed, choked, laughed at, pushed, pulled, dragged, whipped, tripped, stole from, lied, terrorized, threatened, humiliated, forced, degraded, made me cry. Every time he tried to end me, defeat, or destroy. I forgive George for beating me senseless, for trying to sleep because I had to go to work or my son's field trip the next day, for ruining my deceased family's heirlooms, traditions, and keepsakes, my son's furniture, destroying the television we watched together, for wrecking our townhome by breaking windows, punching holes in the walls and doors, ramming his entire body into glass doors, kicking in my front and back door over and over and over, for breaking or removing the locks from all of the doors and sometimes the knobs altogether, so I had nowhere to feel safe, including the sacred space of my son's room where he beat me bloody on his bed. For terrorizing and threatening my blind and deaf dogs by leaving the gate open I built to keep them safe, telling me he hoped I'd find their bloated dead body in the pond or scrape their remains off of the pavement, for kicking them off of the bed and throwing across the room because they were trying to protect me, for threatening to make me unrecognizable to my son by breaking all of the bones in my face, like his brother Moses did to him after he kept seeing all of the bruises from George beating me, like all of the times their father beat their mother, for all of the drunken rages and fist fights with so many neighbors when wandering into their apartments during hunting expeditions after I had escaped, for drowning me in liquor and wine because I didn't want to drink, causing me to urinate on myself, then butting the end of the bottle in my face, giving me 2 black eyes and a bloody nose, for making me experience what it is to be sodomized, threatening to kill my friends and the neighbors when they checked on me to make sure I was alive and in one piece, for threatening to burn down our townhome and set my car on fire because I got a job, for holding me hostage on weekends my son was supposed to come over by keeping my keys around his neck, my phone in his crotch, and a butcher knife stuck in the middle of the table as a warning not to ask anything or try to leave, for stabbing me in the leg and not letting me call 911 for an ambulance or seek help, where I nearly bled to death until I concocted a lie to save him from being arrested, for destroying my phone with a hammer because my son called, for me experiencing ever being arrested and after today, prison, for beating me almost blind, crushing my occipital lobe, for having me experience what it means to see stars like in the cartoons, where a character has a tall lump on their head. I had that too, and many times, for dragging me downstairs by my hair in the middle of the night just to sit next to him, for taking my car driving drunk with my debit card to buy more alcohol while I slept, even after I kindly explained the importance of my car to take my son to school foremost, me to work, and he to his batterers intervention classes and probation officer meetings, where I would be forced to sit for hours in the parking lot waiting for him, for causing me so much trauma and pain mentally, physically, emotionally, I had to be hospitalized more than once, for destroying my reputation and integrity, for my M for murderer scarlet letter, not letting me feel safe to live, talk to other people, spend time with my son, have a job, friendships, simply go to the bathroom with the door closed, or go to sleep soundly or comfortably. I forgive George for lying, for him trying in so many ways, so many times, to end me with his terrifying love. I also forgive the Torres family, his mother and father foremost, also his 2 ex-wives and daughters, all for knowing who George was capable of and has done in the past, his history of violence and where he learned it, than to keep turning a blind eye when I would ask for help. All of his siblings, including Farrell Torres, who is now on his way to prison for stabbing the mother of their baby in the side of her head. For everyone who knew what George was doing to me, sometimes how and when, but allowed and enabled. I forgive them for caring too late. I hope they all ask themselves while quiet and comfortable in bed at night the uneasy question, what could I have done to stop this from happening to both of them? And after all the time Sarah tried to, by asking for help from all of us and so many times. Another great contributor of my gold is social media, with its greed, insensitivity, deception, obvious exploitation, and advantageous gain from my criminal case as a whole, and for sentencing me by anticipation as a result of ignorance and hate, conjured and fabricated by the organized crime that is social media, which condemned me in the court of global public opinion since the beginning. My family law case is the new prey waiting to be picked apart and pillaged from me being made infamous by social media in my criminal case. It simply seems I cannot forgive and be forgiven and move forward. Social media has made me a pariah. It has caused great oppression and undeniable disadvantages, especially by broadcasting and manipulating my cases online. In my criminal case, as a result, my opportunities to be given a fair, proper, and uninfluenced, successful conclusion was heavily depleted and poisoned. I forgive them. Also, all of the media tycoons for not having a life of their own, trying so desperately to make themselves seem so right by making me appear so wrong. Forgiveness for prejudgment, ridiculous theatrics, lies, making and taking blood money from my and others' misfortunes, accidents, and catastrophes. It's all over their hands and their keyboards. And even after all that's been said and done, theorized, hypothesized, scrutinized, and blasphemed in my case, still no one knows me. In the end, I forgive myself for not choosing my life sooner, for not being more brave, vigilant, bolder, and outspoken, stronger, mentally, physically, emotionally, and spiritually, for being hopeless, desperate, simple-minded, weak, and inexperienced. I forgive myself for not realizing I was enduring a life of domestic violence and that the vicious cycle of never ends. I had nothing to compare to. I've never been hit by a man ever before in my life. I was raised hitting a woman was wrong and should never happen. No excuse. I forgive myself for not escaping permanently, for not fighting back sooner to save myself, my son, my dogs, home, and car. Having 20/20 hindsight thinking of everything I could have done differently or better to avoid the outcome. I think about this every day since. Also, of all the good days we had together, for him at least, while I was constantly in hyperdrive, high alert, and paranoid, making sure I did everything right all the time. If not, the great possibility I would be ended as George threatened me with so many times before. I forgive myself for falling in love with a monster, and no matter how grotesque he may become, I still loved him, hoped, and forgave. I tried breaking the spell so he wouldn't be a monster anymore. I saw who he was inside. George made me then, now, and always love him for all of his cracks also. We made each other our own brilliant pieces of art from the cracks and repairs. Unfortunately, not all cracks can be. In all of my forgiveness, George is my greatest lesson and will forever be a part of me. I think of him every day and still speak to him when alone on the rec yard. I ask his forgiveness and that he looks for me at the gates of heaven so I can tell him how sorry I am, endlessly, and that I never stopped loving him. In all of it and still. When I first came to jail, I put my mat under my bed and cried all day and all night for months, only falling asleep from being so exhausted with grief. I wrote him letters. I wrote his family and his daughters apologizing for asking for their forgiveness. But due to fear that my life or sons would be jeopardized, I did not send. I am sorry. I cannot begin to fathom any of their grief and sadness. Please forgive me. Almost everything reminds me of him, seeing my stab wound especially every day especially. It truly reminds me that all I really did live through. George haunts me. He is everywhere. I believe because I do still love him, think of him, and miss his laugh the most. In my heart, I know he is with me and understands that this tragedy was not intentional. I hope everyone can, his family foremost. I didn't mean for this to happen. Please wholeheartedly know that, and always, I would never. Forgive me, George. Forgive me, Torres family. Forgive me, Judge Cranick. To the entire planet, please forgive me. I graciously and humbly ask for consideration, for forgiveness to be extended instead of judgment, for reconciliation and restoration for all of us to move forward. My apology is profuse and ceaseless. Allow me, please, to brush off the muck, wipe the blood off of my face, and fix the cuts in my skin. I ask for understanding in what really happened and for how long, for second chances, repentance, and redemption, to advocate for all domestic violence survivors, to help them overcome, heal, and still hope, always, to make their voices heard, to confidently walk with all of their scars on the outside and the inside, to help them not ever become a casualty of domestic violence as so many others, to stop the abuse and maltreatment before it's too late. There is always hope, and you can survive. In my soft-spoken conclusion, I ask this: would I be the darling mother, celebrated woman of the year, if it were I who died? How many daughters, mothers, sisters, aunts, grandmothers, nieces, and friends have been because they did? I am a survivor. Learn to do good, seek justice, rebuke oppressors, defend the fatherless, plead for the widow. Isaiah 1:17, all-encompassing, protect the abused.
Ms. Boone, is that the end of your written statement?
Yes.
Now, gathering your thoughts, did you want to make an oral statement?
I do.
Would you do that now?
Yes, please. My statement, my verbal statement, is primarily to the Torres family, to the judge, to his daughters. I know you all know who I really am, and that I did care for George, and that I do still love George. I know you know that we had very many good days, and I take offense to the statement of being said that this is just for a moment. Right now with me here in the courtroom in front of you all, this is just for a moment. But the moments before that, in order for me to be here, is endless. It's everlasting. The scars that I have on the inside, my outside scars have healed, except for my stab wound. But this has changed me as a person to see things differently and to understand things differently and to not be weak and just try to protect yourself, and forever, regardless of the time that I may receive from today, I forever will have this experience. I forever will have George Torres with me in my heart, in my mind, my body, and my soul. As he and I used to say that we were one soul split into two bodies. This is not just for a moment. It may be for everyone in this courtroom, but when I leave, this is forever. When you all leave, that this is forever. This is forever for everyone here and those who it matters to most. I am one of those who will experience this forever. I'm sorry. Words do not define my shame, and I don't know what else it is that I can say and convey to the Torres family how this happened. The ifs and whys and how really don't matter. It happened, and I'm sorry. Words cannot describe. And I hope that everyone can forgive me, the Torres family most of all, and his daughters, because I know what he meant to them. And I don't think that anybody ever understood what he meant to me and I to him. And I ask for forgiveness.
And I have just one or two questions, if you don't mind. And you can speak on it if you want, or not. And this is a unique case, and one of the reasons it's so unique is that you were in jail for 4.5 years prior to your trial. And I understand that when you were brought up as a child, that you did have some spirituality in your family, some church, some religion.
Always.
But I understand that you got away from that. Did you have a chance during the 4.5 years to look back at your spirituality?
Absolutely. You know, everyone's supposed that this is one of the worst experiences of my life, and it's actually been one of my greatest. If I were not beaten to death, I was going to work myself to death on the outside, and I never had time to get back into my Bible and to pray and to be with the Lord. And I, being here incarcerated, have had time, of course, to get closer to God, to reacquaint myself to Him and realize what it's all about. This is all temporary. And when I say temporary, I don't mean by being set free in jail or from prison or wherever else. It means being set free and temporary, meaning that you work for something higher. You work for God, that you strive for your crown to be placed upon your head by Jesus Christ by being said, "You have done well, my good and faithful servant." I've always tried to be a good and faithful servant. I was just a servant as opposed to doing all that I can when my family were alive and I was going through everything up to this point. I've become so much more closer to the Lord, and it's made me such a better person, and I hope that I am an example going forward of the Lord's light and can draw many people to me because of it.
Any follow-up, State?
No, I assume that was the final word.
Thank you. She can return back to council's table. Anything else from your side of the ledger, Mr. Owens?
No more witnesses.
Bye, girl.
Just arguments.
Okay. Anything else in rebuttal or just proceed to argument, State?
Just proceed to argument.
Okay. All right. Once Ms. Booth's seated, you can proceed with your argument, either Mr. J or Mr. Cacciatore. You may proceed, sir.
Your Honor, I'm going to start my argument by what I anticipate Mr. Owens will bring up in his presentation regarding the plea offer in this case. That she was offered the resolution in this case of 15 years in the Department of Corrections to begin with. I think it's important, though, that the entire circumstance of that plea offer is put forward. And there's something very critical to that. It's not just 15 years in the Department of Corrections. It's 15 years in the Department of Corrections, but it's predicated on something. And the consideration that it's predicated on is the defendant coming to court and accepting responsibility for her actions. For her coming to court and saying, "I am responsible for George Torres's death, and I accept the punishment that comes with it." That consideration was never given in this case. And because that consideration was never given in this case, the offer of 15 years in no way represents what this case is worth, or what George Torres's life is worth. That is an offer predicated on a particular circumstance, a circumstance of a first-time defendant accepting responsibility and giving every benefit of the doubt and coming to court and saying that they are ready to be punished. Those conditions were never met. So then we turn to this case, and we turn to this crime. And we turn to the actions of the defendant of taking the law into her own hands in murdering George Torres. She has never shown remorse for that. She didn't show remorse for that here today. She again painted herself as the victim. She's the victim of George Torres. She recounted the litany of evil deeds and mistreatments that he perpetrated upon her. She's the victim of George Torres' family. She's the victim of the police. She's the victim of social media. It's all about Sarah Boone. Everything's about Sarah Boone, about how she is the victim. But Sarah Boone sentenced every one of George Torres' loved ones to a life sentence. Just like she sentenced George Torres when he was in that suitcase. George Torres lived out his last nightmarish circumstance in that suitcase, begging to be let out for several minutes, which undercuts any argument that this was somehow unsophisticated. There was ample time and opportunity over and over for her to do something different, but she went forward with taking the law into her own hands and ensuring that George Torres was never getting out of there, while she went up to bed and went to sleep for hours on end. She can't say that she was in duress for the same reason. She was in such duress of George Torres that she goes upstairs and goes to sleep for 11 hours. Your Honor, there's been nothing from the testimony of Dr. Harper either that establishes any type of diagnosis that would give this court a basis to downward depart. Dr. Harper has put blinders on to the fact that she has been incarcerated for 58 months. 58 months with the opportunity to receive mental health treatment, and the expert witness is absolutely incurious about what any of those records or diagnosis or anything that would have been there would have said. There is no valid basis for a downward departure in this case. She deserves a life sentence. Thank you.
Mr. Owens, response?
Just credit. First off, I want to thank you for taking the time to hear our side, hear the witnesses, and review the letters on Sarah Boone's behalf. You know, we've all been here for this trial. We've all been here for other trials. We've all got some age on us. We've all got some life experience on us. And this is a unique case. This was a unique homicide. It was a unique death. And as we all know, a lot of these cases are not black and white. They're shades of gray. And these crimes don't occur in a vacuum. That there's generally a history, especially involving a domestic couple, a history that comes into play that must be explored. And a lot of what Sarah Boone testified to here today probably happened behind closed doors. And we all know that many times we do not know what happens behind closed doors between a man and a woman in their home, unless there is some reason for the neighbors or law enforcement or somebody else to get involved. And that happened in this case. And so gradually over time, as this event occurred, there was an investigation, and it was learned that there was a history of domestic violence involving these two parties. And what we learned was that physically there was violence, and there were photographs to establish that, as were introduced in the trial. And then there was testimony from experts, not only the defense expert, Dr. Harper, that Sarah Boone was the victim, and she was a victim of intimate partner violence, but coupled with the fact that the state's expert testified on the stand at the trial that Sarah Boone was a victim of intimate partner violence, that she suffered from this domestic or this battered spouse syndrome as the hands of George Torres. So there's two sides to it. And in a domestic violence situation like that, 95% of the women get out of that relationship. When violence starts to occur, they've either been raised a certain way, they have a certain self-esteem about themselves, where they refuse to put up with it, knowing that it's wrong, knowing that they can do better. But there is a small percentage throughout the country that, for whatever reason, mental health issues, addiction issues, whatever it is, it's complex. Financial reasons, children are involved, whatever. If you do any studying on it, there are circumstances where there is a group of women, predominantly women, it can happen to men, but majority of the time it's a woman that gets caught in this cycle of what we term as intimate partner violence. And court heard the testimony about the cycle that occurs. It's over a period of time and it repeats itself, and you go through these phases. And a lot of times the victim's not a great historian at trying to articulate it. She tried to do it here today. And I think on Sarah Boone's behalf, she is a unique individual. She's got the personality that she's got. I don't know, you heard from Dr. Harper that a lot of that was formulated based on the way her mother did not bond with her, the way that her father was the way that he was, the fact that she lost several relatives at a young age, and the trauma that can result. We heard from Dr. Harper that she did suffer from post-traumatic stress as it relates to that trauma in early childhood, and then again as it relates to the events that occurred between Mr. Torres and her. So it's complicated, Judge. It's complicated, but the jury has spoken. Sarah Boone was entitled under Florida law to present that defense, and she did. That testimony was allowed to be presented. She was allowed to testify. But the jury spoke. And so here we are today with you in a position to decide what is justice for Sarah Boone. And I don't know you that much other than our time together, but from what I know you try to do the right thing. And that's what we're asking the court to do. To have some discernment, to have some understanding of the unique situation that Sarah Boone found herself in. And quite frankly, Judge, this all didn't occur behind closed doors. A A lot of this was in the public eye. Mr. Torres had, I believe, 3 criminal cases before the courts of this county in which Sarah Boone was a victim. Mr. Torres was the accused. Those cases were dismissed. We know from the history of this domestic violence field that that's normal, that Sarah Boone every time either tried to bond him out or tried to get the case dismissed. At some point, somebody has to stop. Somebody has to say, wait, what's going on here? This keeps repeating. It's going to get worse. Something's going to happen. The system failed, Sarah Boone. I'd ask for you to consider that. Circumstances surrounding that failure and what led us here today. I've asked the court to consider a downward departure. I believe you've gotten a copy of the score sheet.
Not since before trial.
Okay.
Is the score sheet stipulated to?
Yes, sir.
All right, you may approach. Thank you. Yes, sir.
Judge, I was provided that here today, and I believe, I can't remember the total number of months that it involves, but divided by 12, I think it's 20 months. 20.6 is the low end of the guidelines or something about.
It's 246.0 months based on the score sheet.
I did the calculation, but I believe that the low end is 20 years. I'm sorry, 20 years, 20.6 years state prison, I believe is the low end.
20.5. Yes, sir.
And as the court knows, I believe it's on page 3. There are some aggravators that the court can consider in opposing the sentence, and then there are a list of mitigators that the court can consider in downward departing, meaning going lesser than the low end of the guidelines. And in the defendant's motion for downward departure, we mentioned, and I had Dr. Harper testify about 2 or 3 of the grounds, and the court needs to only find 1 to go below the guidelines. The capacity of the defendant to appreciate the criminal nature of her actions and to conform said actions to the requirements of the law were substantially impaired. Judge, I don't have to reiterate the facts and circumstances surrounding this event. You were here, you heard the testimony, you heard the circumstances surrounding what happened and how it happened. I would ask that you consider that as a mitigator. 2D, the defendant requires specialized treatment for a mental disorder that is not related to substance abuse or addiction and is amenable to treatment. I think it's fair to say here that we know that Sarah suffers from some mental health issues, objective mental health issues that have been opined by Dr. Harper and Dr. Werner. And you heard Dr. Harper testify about the borderline post-traumatic stress disorder that she suffers from as it relates to this event, as it relates to her trauma that occurred in childhood. I think we heard from Dr. Werner. Dr. Werner testified that she suffered from the alcohol abuse disorder, as did Dr. Harper, but Dr. Werner also mentioned that she was not for sure about the anxiety disorder, whether it occurred prior to or because she was in the jail for the 4.5 years. However, she does require specialized treatment for the mental disorder, and she is amenable for treatment. And then third, the defendant acted under extreme duress, I think based on Sarah Boone's mindset as she testified to her today, and then you heard from the experts at the trial that when you get that anxious about what happens, testified about they would have good days where there would be no drinking or very little drinking, and then there would be other days where there was heavy drinking. And generally when George Torres got highly intoxicated is when potentially things could get violent, and that she was constantly anxious about each day that she was with him. She loved him. Obviously, being in a cycle like that where you love someone but can't leave them. For whatever reason, George Torres couldn't leave Sarah Boone, and Sarah Boone couldn't leave George Torres, and it was a vicious cycle. But we believe that she qualifies under that it was under extreme duress at the time of this event. And lastly, the defense was committed in an unsophisticated manner, which was an isolated incident. Now, isolated, we know, Judge, that she had one prior event in which both of them were arrested. You heard her testimony that it was during an event. They ended up downstairs next to the washer and dryer, and that she was on the bottom, and she had used her hands to try to get him off, and she had tried to choke him, and there were some marks on him. And she was arrested for domestic, I think, felony domestic violence battery, as well as he was arrested. I think a few days later, both of those charges were dismissed against either party. But she has no criminal conviction record. She has never been convicted of a crime other than that event. Now, I think that can be distinguished. So we believe that it was an unsophisticated manner. Obviously, the uniqueness of this event is unsophisticated. Anybody that would calculate that they were going to murder somebody by putting them in a suitcase and let them spend the night, and the next morning not try to dispose of the body, not try to put the suitcase in a car and go dump the body, not try to dispose of the bag, do something. She did nothing. No attempts to tamper with evidence. No attempts after the fact to uncover any conduct whatsoever. No attempts to delete the videos from her phone. Here's my phone, voluntarily given that information. I think that goes to the unsophisticated manner and unintentional death that occurred. I remember the first time I saw the Suitcase video. And I know people have differing opinions. Tony Henderson, my colleague, had a different opinion when he saw it. But I remember the first time I saw the video and I heard what she was saying to him. When he was saying, "Hey, Sarah, let me out. I can't breathe," or words to that effect. And the way that she was talking to him and the statements that she gave him, in my mind, what has he done to her? What has he done to her? Any loved one you see in a situation like that is going to run and let them out. So my thought was, obviously, they were both drinking. But what has he done to her? And I think it's telling about what she'd endured. So it's not a clear-cut case, Judge. It's not black and white. There is some gray. And it's up to you to decide what's appropriate based on the court's, based on the jury's decision. But I would ask you to temper whatever justice that you think is appropriate with some mercy, and consider the fact that the state was willing to offer 15 years on a manslaughter as a lesser included offense based on the facts and circumstances that they were aware of prior to this trial. Thank you.
Thank you. Any rebuttal by the state? Court has had the opportunity to review the evidence and testimony that was presented at trial. The victim impact statements presented here today, the statements of character witnesses, both orally and in writing, Dr. Harper's report and testimony, the defendant's testimony, pre-sentencing investigation, the arguments of the state and the arguments of the defense. Court pronounces sentence as follows. Ms. Boone, court sentences you to life in the Department of Corrections with credit time served that Madam Clerk will provide to you momentarily. There are also court costs and costs of prosecution, which Madam Clerk will give you the totals of momentarily. Due to the court levying a life sentence, the court is inclined to liquidate those to a civil judgment unless I hear opposition from the state.
No opposition, Your Honor.
All right. Madam Clerk, if you could please give us the credit time served and the court costs, please.
4 years, 9 months, and 8 days, and the court costs are $418, a state prosecution fee of $100, a dirt fee of $50, and a PD.
I'm right.
So the total would be, come to, $618.
All right, ma'am, the court costs and costs of prosecution are $618. Those will be liquidated to a civil judgment. You will be given credit time served of 4 years, 9 months, and 8 days. You will have 30 days from today to appeal the judgment and sentence in writing. If you cannot afford an attorney, one will be provided to you. I'm going to have the courtroom deputy provide you the paperwork. Because you've been incarcerated for the last 58 some odd months, the court is going to declare that you are indigent in this matter. I cannot appoint the public defender to represent you as they are conflicted out. Similarly, I cannot appoint the regional conflict counsel to represent you for the same reasons. The clerk will appoint an attorney from the conflict wheel who specializes in appellate litigation. And again, you'll have 30 days from today to appeal that judgment and sentence in writing. Do you have any questions for me? You will now be remanded into the custody of the Orange County Jail to transfer you to the Department of Corrections, and I wish you the best of luck. State, anything further?
No, Your Honor.
Defense, anything further? All right. Thank you all very much. Court's off the record.
Yes. Yes. Okay, he said without parole, right? Because I got excited and I forgot to listen closely. She's so mad. Justice, justice, justice. Thank you, Judge Kranick. We knew he was going to come through. We knew he would, y'all. Jamie screamed my face off, she said. Brilliant. Not just practically life, but life. He said no parole, right? Who jumped? Scott said, who jumped up into the happy dance? I would have if I didn't have headphones and mic on. You've been cranicked, Sarah. Look at her looking back at the family. You don't have a right to look at them. You keep your face forward. You leave them alone. Don't let her even look at them. Oh, that's right. There is no parole in Florida. I forgot about that. That's right. There's no parole in Florida, y'all. She ain't getting out. She's not getting out.
She's on her way. Okay. Can you just give me a heads up when they get her here? Yeah, I got you. I gotta go down.
And you know what she's thinking about now? She's thinking about the money she's going to make now from the trial. And so is Jamie. And Jamie's like, now, Sarah, about this thing, this deal we made. You gonna let me get the book rights, right? Right? Sign your life away right here, please. And then we're gonna take your fingerprints once again. I do. I feel sorry for everybody in the cell block too, Kristen. I'm so happy for that family, you guys. We got justice for George today. Yes, we did. We have not heard the last from Sarah Boone, y'all. I can guarantee it. Look, James has already got his jacket on. He's ready to go. He's out. He's like, yeah, just take her. Whatever. I got the book rights. Oh my gosh. She needs to stop looking back at the family. That's making me so angry. Who is she talking to? Who is she looking back at? No speech from Kranick. I don't think Kranick needed to. I think, you know what? He's above all that. That's what I love about him. It's like when he tells you that something's been denied. He's above it. He's like, I don't need to tell you. I'm good. You know exactly why I said no. You know exactly why you got denied. You know exactly why you just got life. I forgot all about that, y'all. Thank you for reminding me. No parole in Florida. Yes, thank you, CB, for your super chat and the one you did earlier. I appreciate you. Rest in eternal peace, George. I don't think it could have done it. I don't think we could have done any better with that, y'all. We got exactly what we wanted. He's like, okay, Sarah, I gotta go because I got family waiting on me. You have a good life in prison. Yeah, I'm gonna refer you over to an appellate attorney now. Good luck with all that.
She's signing it now for you. Perfect, thank you. Yeah, we'll file it and then we already ordered to appoint another attorney. Okay.
You're right, Kultina. She did it on her own, didn't she? She did all this on her own. She can't blame it on anybody but herself, but she will blame it on everybody else, obviously. She'll never blame it on herself. And the other best part is that her husband and her son can now go live their lives without her. She said that she enjoyed being in prison, so there you go. Maybe she really will find God after this. Yes, Merry Christmas, Happy Holidays, Happy New Year, Happy Thanksgiving, Happy Birthday. She's trying to hold it together, but she's going to lose it eventually. I don't know. Do you think she cries ever? Now everybody else gets, you know what the best part is? Think about this way, guys. She's looking around the courtroom. Everybody else in that room gets to leave and go do life. They get to go and do what they need to do now. Her mindset, what she's probably thinking is she has to go. She doesn't have that. She's waiting on the guards to finish her paperwork so that they can tell her where she's got to go and take her where she's got to go. And for the rest of her life, she's going to be controlled. And for somebody like her who likes to be in control, it's got to be the worst thing ever. So it's like a double whammy. You know what I mean?
Last week you played it there. So yeah. That's a female? Yeah.
See you later. Look at him. I'm gone. He doesn't even wait for her. Most attorneys would sit there and wait until she's taken off. She's trying to keep a even face for the camera. I can guarantee it. She's all about what everybody thinks about her. Jamie said, I got a plane to catch. That's hilarious, you guys. Just left her sitting there. Yeah, now get your kidneys out there and Pep. She got a good kidney. She's an alcoholic. And Cookie says, I just hugged my cat. Thank you, A. Martinez. God bless you, honey. Yeah, the worst, the next best thing would be a padded, well, not a padded cell, but a straight jacket for her. And the next worst thing is that nobody's paying any attention to her and she can't stand that. She likes to get all the attention, right? Yeah, we know the kidney story. She knows her kidneys aren't any good. They should have asked her if she needs anything from Publix as they left. You need Pop-Tarts or anything? Some cheese? Oh, how about some peppermints? You think with somebody like Sarah, do you think solitary confinement is worse than being in a cell with other people? I think she enjoys people too much. Sobriety for whatever that is can be in prison. No staples. It's going through her head right now. It's sinking in what just happened. You know, that's true, Bart. I forgot that. She's been sitting in jail, so she doesn't think it's that bad, right? But now it's prison. So I wonder, does she feel like she's going to be fine? Like she's got this or whatever. But no, now it's a different story. It's a new place. She better hope her fans continue to send her money so she can buy them via commissary. I saw some puffs of smoke coming out of her ears, yes. Did I miss any of you guys? Nana says, I've been a member for 1 month. Nana, I thought you've been a member for longer than that. We love you too. Expecting Mr. Henderson to wheel in a big cake now, and Margaret tries to burst out of the cake, but it's broken, and Sarah gets 50 years. Damn it. Damn it, Margaret. I missed that, Gentai. I'm sorry I missed your super chat. I think there was another one I missed too. I apologize, you guys. Oh, I did. I missed a bunch of y'all's. Hang on. How'd I do that? Bye, Sarah. Janice said, if Cranick doesn't send its Looney Booney to 40 or more years, I'm going to lose my shite. I agree. Thank you for your super chat. Sorry I was late with that one. Oh, you know, everybody's so relieved, you guys. I don't have to deal with her anymore, or in the suitcase in this case. Thank you, Matthew, for your super chat. Again, sorry I'm late. Emily said I clearly barfed in my mouth too soon. Thank you, Emily. Insert barf goof. Barf face gif. This is the anger shining through like gold. Yeah. Yep. Oh, and Barbara, thank you for doing a membership. I missed that one. I know I missed that one. Thank you so much. I think I got everybody else, though. I think I got them all. Did I miss anybody? Oh, hope not. Hang on, I'm going through right now. Let me see. Let me just double check. I think I got everybody. Thank you guys so much for being here with me through this trial and sticking with me through all of the extras that we did surrounding this trial. We hope to do something similar with the next one coming up, and the big one. We're gonna. Oh, hang on. Let me turn this off. We're going to be doing other trial pieces here and there, looking at different cases that come up and just kind of touching on them. But the other trial that we're going to really sink into next is the OnlyFans model, Courtney Clemens. So please stay tuned. Don't unsub, and be on the lookout. Don't go far. You guys have a blessed day. I know it's going to be a blessed evening for everyone, considering what we've just heard. This should keep us going for a little bit, right? Thank you all so much. Y'all stay well. And I will talk to you very, very, very soon. Night, everybody. And one last time. Let's do the song. One last time.
Down and under it, just a twisted pink paper clip, clinging to a hidden jacket zip. Know that you won't get it or quit. Yeah, know that the hour is drawing near. The case is resting, Sarah Boone should fear. She might soon be shedding actual tears. Down and under it, just a twisted pink paper clip, clinging to a bit of jagged zip, doing nothing more than slip and stick. As Sarah tries to hide her abusive lies, but know that no, it's you, Sarah, we all despise. Leaving you with your lifetime of demise from your sad attempts being the victimized. Know that, yeah, know that. All that you're really gonna see is Prosecutor Jay giving proof to the jury of your murderous pine for commissary. 6-panel conviction arrived at convincingly. Oh, Sarah, can't you tell that your time has come to ring the bell? And let your fans throw you some small slice of hell. The bailiffs will be waiting, cuffs in hand, since you fumbled and flopped all over the stand. So go on, say bye to your circus jaunt. Go on ahead, keep pretending to flit and flaunt. You'll soon be in your brand new prison haunt. Damn it, Margaret. Oh, Sarah, know that now is your time to return to your jailhouse lies. Your face and sob story past its prime. Yeah, know that. All that you're really gonna see is Prosecutor Jay convincing the jury of your murderous and dangerous lies. A sad attempt at trying to be the victimized. No, not happening on board DAJ Enterprise. Clip, clinging to a bit of jagged zip, which does nothing more than slip and stick. As Sarah tries to hide her abusive lies, but know that no, it's you, Sarah, we all despise. Your angry and controlling attitude won't spare you any grace or fortitude. From the truth, the jury all can see that the time is here, your taunts aside, to return to your crummy jail slides. Your face and sob story are past the prime, so go on, say bye to your circus jaunt. Go on ahead and keep pretending to flit and flaunt, because you'll soon be in your brand new prison haunt. Damn it, Margaret. Just a twisted pink paper clip, clinging to a bit of jagged zip. Yeah, know that you won't get an acquit from all your murderous and dangerous lies. Pathetic, you claim to be the real victimized. No, not happening on board DAJ Enterprise. Damn it, Margaret.